this, he would do something like this. He says, no, the lights are too strong. But why I am mentioning the name of this illustrious personality? The reason is empathy was the hallmark of the man. What has been honed in the session this morning by eminent speaker after speaker is empathy. That has to be taken note of while adjudicating upon child custody matters, child custody proceedings. Now, what has happened is there has been a fundamental shift in the case law, the jurisprudence in the last 5 years, handed down by the Honorable Supreme Court of India and various high courts across the country. Shared parenting plans are on the top of the list. So we all have discussed this morning, the eminent speakers have discussed this morning, that the child should not be used as a trophy. Then, secondly, the core emphasis has been on child-centric jurisprudence. It is the rights of the child or the children which are far more important than the rights of the parents. Thirdly, what has now become very important is mirror orders. See, they have been conceived by judicial intervention. Orders of Delhi High Court, Supreme Court of India have been successfully implemented as mirror orders in decided cases. Quite often what happens is in cross-border proceedings, foreign judges ask you, is there any sort of ironclad guarantee that the removed child or abducted child, to put it very bluntly, will be in a position to come back to his foreign country of his habitual residence where he's permanently domiciled? The answer is, of course, no, because we do not have the concept of statutory mirror orders, and the mirror orders by way of judicial intervention are in fact plugging in as of now for lack of legislative lacuna. So what happens is, very often where parents are litigating or are in the process of separation, the foreign court judges often ask for expert reports. Not that they are binding or they can be mechanically enforced, they have persuasive value. The question then is, after analyzing the position in Indian law, what safeguards are to be put forward? Firstly, it is a letter of request by the foreign court to the Indian court where the child is likely to be visiting with the visiting parent coming to India to the native place, say any particular state. So this letter of request, ideally speaking, should be accompanied by a notarized agreement by both the parents, duly sworn, placed before the foreign court where the proceedings are going on. Ideally speaking, this letter of request has all details regarding travel plans, where the child will be traveling, and there are reported cases which have taken cognizance of such letter of requests. This will have the details of the passport of the child. There can be a request to the Registrar General of the High Court of that particular jurisdiction to take the passports in their safe custody. And of course, this order can be also sent to the foreign mission or the consulate as the case may be. Furthermore, there should be an undertaking by the visiting parent that he or she will not apply for fresh passports, emergency passports, or emergency exit visas, and will not flout any sort of conditions. See, in fact, what happened was, I did an expert report in one of the reported cases by the High Court of London in the year 2005. The title of this highly publicized but anonymized judgment, if you could, the dear students, take a note of the citation, is REKR, Abduction, Forcible Removal by Parents, 1999, to FLR, which stands for Family Reports, page number 542. So it was a blanket request to all administrative authorities and all judicial authorities, including the British High Commission, to lend support to a girl who was under 18. She was brought to her village in Punjab for a forced marriage, and fortunately, before she turned 18, she just convinced her parents to go back to the British High Commission, and she was sent back on the plane, and she was actually saved. So, as I said before, these agreements only have persuasive value. They are not binding. After all, obviously, all the courts the way the law is, will come to their own independent decision on the merits of the matter, irrespective of the financial standing of the parties or from the foreign court where the such order has been passed. So much more recently, in the month of January, Honorable Justice Sanjeev Kishan called in a contempt petition in para number 19 of the judgment. This is called the case of Meenal Bhargava. He said, we also feel that India may not be a party to the Hague Convention. There may be possibility of entering into mutual agreements with USA as the number of cases rising is very, very high. In fact, there has been a lot of debate going on India signing the Hague Convention on the Hague Convention on Child Abduction. There are both sides of the coin, against and for. And in this connection, what had happened was in the year 2005, the president of the Family Law Division of the High Court of London had initiated a judicial protocol between UK and Pakistan. But that took off on a limited scale. And yesterday only, I in fact got in touch with my lawyer friends from England who's dual qualified. So I asked her, is this still up and running? It was modified. What's happened about it? She said it got underpinned. It did not fizzle out because it did not have judicial or legislative sanction. Now, one more place where we need to plug in, as I have seen all the efforts that have been made in the last 2 decades for India to sign up to the Hague Convention. Now, what I feel is, on the administrative side, especially with the central governments, there is some sort of lack of coordination. There is a sort of a connect which needs